Welcome to Cannabusiness Live. My name is attorney Barton Morris, and with Nick Galendez, we are attorneys at the Cannabis Legal Group. We bring our show, Cannabusiness Live, to you every Friday in order to talk about the cannabis news in Michigan and throughout the country.
As Barton mentioned, Cannabusiness Live is a special feature of the Cannabis Legal Group. We try to show every Friday. This is our 101st episode, and we try to keep up to date and stay most current with cannabis news in Michigan, federal level, and even internationally. It's definitely something we're proud to do as an educational and informational outlet since we're on the ground, moving target every day. So we're very happy to bring that to you and be kind of a source of first primary information.
To begin our show today, we have a great show today, very special. Last November 2018, Michigan voters voted overwhelmingly to approve and legalize the adult use of recreational marijuana. Shortly after that, our new governor, Gretchen Whitmer, created the Marijuana Regulatory Agency, and about six or 7 months after that, that regulatory agency created our emergency rules. They were introduced July 2nd or July 3rd. To govern the adult use industry by the regulatory agency. It was signed by two individuals at the end of that document. One was the governor, Whitmer, and the other one was the director of our regulatory agency, Marijuana Regulatory Agency, Andrew Brisbo. And we are very pleased to have him today to talk about some of the issues that are enumerated within that document. So thank you very much, Andrew,
Sure.
Or Director Brisbo.
It's my pleasure. It's been a while.
Yeah, we really very much appreciate having you on the show. So, first of all, I'd like to talk about the fact that the Regulation of Taxation of Marijuana Act called for the regulatory agency to begin taking applications in December of 2019. It seems as though that with the implementation of these rules that the regulatory agency is going to be able to do so perhaps a bit earlier. How is that important to your agency and perhaps to the industry?
Well, I think we had the goal all along of trying to leverage the infrastructure we had in place so we could do it more quickly. The idea being that the sooner the regulated market takes shape and can provide access for consumers, the more we can combat the black market and drive consumers into the regulated market. And with the way the Act is set up and the opt-out provision for municipalities, we knew that they were going to need quite a bit of time after we promulgated the rules to determine how they wanted to approach it in their local jurisdiction. So this gives us time now that we've implemented these in July. We're going to start taking applications in November. They have about 4 months to look at the rules and figure out how they want to address it locally, and then we can still take applications before that deadline.
You are very right in that a lot of municipalities have been waiting for these rules to be enacted in order for them to be able to take the steps necessary for them to participate. We see that a lot at our law firm. A lot of cities are like, no, we're going to wait and see. Now they see exactly what's available, and they're allowed to form their ordinances in accordance with the rules. And so you're absolutely right about that. With respect to these rules, I know that a lot of people have had the opportunity to and are probably reading everything word for word right now as we have already. And some of the most important and exciting things in there, and I mean exciting, this is really kind of a roadmap of how we're going to see our industry kind of play out within the next few years. One of the most exciting things in there is the establishment of the temporary organizer, or the marijuana organizer's license and the temporary events license. Can you talk about the importance of these types of licenses?
Sure. So these events have existed in Michigan for several years now. We know that it's something that consumers want to see. And we know that these event organizers have established relationships with a lot of these communities. So I think it's important that we have a regulatory framework that gives us the ability to vet who's running these events and have some sort of oversight over them as well. And I think the approach that we took allows us to issue those licenses to individuals or entities that want to organize the events, and they can go through that process. And then there's a separate fee to be paid for the specific events, and we can ensure that wherever the event's being held, that the municipality approves of that location, and we can have an understanding of the scope of the actual event itself, how many days it's going to go on, whether there'll be sales or consumption at the event, and the fee structure for the event itself is based on how much of that activity is going on in the scale and scope of the event so that we can appropriately assign some of our resources to ensure compliance for that event.
Yeah.
And I also was going to just talk a little bit about those different license types. It seems like what Barton had mentioned previously was the designated consumption establishment license, which seems like it's kind of another added layer to what you're already, one of the other license types if you want to be a special designated kind of certification above and beyond that. And then the marijuana event organizer, that's good for a year. Correct me if I'm wrong, but you also kind of apply for that, and then whatever special event license you want to do can be minimum of 1 day, as long as a week, and it has to kind of specify where it's going to be, what kind of licensed facilities you're going to have there, and kind of get approval from the MRA before you actually have these licensed events. And I think one of the important things in it was that the MRA actually identified, anyone who charges a fee, who has membership, who is serving goods and services while the consumers are in the club needs to apply for one of these special licenses. So kind of being more broad, but also kind of indicating exactly where, or what types of business models and types need to actually get this special license.
Right, yeah, we want to make sure we don't provide too onerous regulatory requirements to achieve licensure. And we want an environment where businesses can be successful. But any operation where there's sort of a commercial operation, that whether it includes sales or not, if products are being consumed in a commercial capacity, I'd say at a business that's charging a fee for entry, that's specializing in providing these access points, that there's a public interest in us knowing where they're occurring and ensuring they're meeting a minimum set of safety standards before we have people there.
Yeah, that's very good. And I also noticed, too, that with that type of license, especially the temporary event one, you kind of charge whether products are being sold there, $500, I think, per vendor, also per day. So I think, kind of goes to our next topic, which is just, tiered licensing application fees. There are a lot of different changes, I think, that are pretty exciting from the MMFLA system to the adult use system. So if you could talk about, I know one thing Barton mentioned, the capitalization requirement is gone for adult use. Could you speak a little bit to why that happened? It seemed like the regulatory assessment fees, which were $66K a year, are now more specific to the different size of the business, and then even renewal fees also are kind of on a tiered system.
Sure. So speaking first of the capitalization requirements, we certainly heard a lot of feedback about that on the medical side. And in the Medical Marijuana Facilities Licensing Act, it specifically calls out financial ability and capitalization as a prerequisite for licensure. So in the rulemaking process, what we tried to do was just provide some clarity around that and set specific standards. So there was consistency being applied, and everyone who wanted to be an applicant had some sense of what the expectation would be. The adult use ballot initiative doesn't include that component of capitalization, so we didn't build that in as a requirement. I think the statute speaks pretty specifically to where we should be heading when it comes to qualifiers for licensure. So I think that was sensible for us to take that approach to it. And as it relates to fees, again, the statute specifically addressed the agency creating a fee structure that had some basis in sort of the size and scope of the operation that's being licensed there. So I think it made sense for us to vary those fees. And in general, all we're looking to do with the fee structure is to support the costs that are required by statute. And in both cases, medical and the adult use side, we have to bring in fees to make sure that it offsets our cost for implementing the program. On the medical side, in terms of the regulatory assessment, a couple of factors there. When those fees were set last year, there wasn't a lot of data for us to base a decision on how many types of licenses we were going to get for each class. So we just made it a flat fee across the board based on our best estimates on how many applications and how many licenses we would issue. On the adult use side now, we can look at some of that data and have a better sense how many licenses we'll issue in each of those classes of license there. And then when it comes to tiering the structure for the renewal fees, it gives a little bit of leeway for newer licensees who are subject to that renewal fee. If there are smaller operators, both with not even in separate classes of licenses, but within the licenses themselves, that it gives them a little bit of give in terms of those fees, so they're paying a more representative share of those total costs as well. And the ballot initiative speaks to the bites at the apple for the excise tax that's put into the fund. We actually get to have the first bite there to cover our cost of implementation and administration of the act. But I think it's important that we set those fees to completely offset our costs and do our best in that regard, so that all the excise tax money that's that's collected can be used for what I think the voters wanted. They wanted that 35% to roads, the 35% to schools, the distributions to the municipalities, and the funding for the research studies. So if we set up the fee structure in such a way that we can cover our costs, all that money that's collected via the excise tax can be used specifically for those purposes.
Very cool. And then, one more thing, and I'll kick it back over to Barton. You mentioned how the ballot initiative kind of dictated the types of rules and kind of steered the direction of the MRA and what types of rules were included and kind of, compared to the MMFLA where you were hands were a little more tied by that legislatively passed law. One thing I did note too, that there's different eligibility requirements that are, I know the ballot initiative had in there, that are reasonably related to kind of, being in business in the industry, as opposed to that laundry list of disqualifying factors for the MMFLA. So things that I saw in there that were positive, fewer barriers to entry were, the criminal conviction had to be solely related to distributing to a minor. Even for employees, there was, that same language that allows for more people to work within the adult use industry. And then also, acknowledging that was an automatic disqualifier, you're kind of looking at, more of a permissive, have the option of denying them if there's a pattern or practice that kind of dictates that to the agency that the operation won't be run with honesty and integrity. So I thought that was that opened it up a little bit more to interpretation in a good way. I think is just kind of another, along with the tiered licensing fees, opening up the floodgates a little bit more to allow more people to participate, I think is a very good thing.
We want to create an environment where it's more inclusive for all types of businesses, for the different sizes of businesses, and obviously there was a clear intent in the ballot initiative not to exclude people that had certain types of previous convictions related to marijuana specifically. So we took that to heart when we looked at what we were going to put in the rules when it came to eligibility requirements, and tried to really only include things that we thought directly might have a bearing on someone's ability to operate in a compliant manner and therefore potentially impact public health, safety, and welfare. And if we couldn't make that argument conclusively, then we didn't include it as a requirement.
Let me talk about that a little bit further, because the elimination of minimum capitalization requirements definitely eliminates a barrier to entry. Although we all know that it's still, the agency is not going to take applications from anybody else except for those that are licensed with a medical license, except for microbusiness and for Class A. So it still is there a little bit. But with respect to the designated consumption license, which is another special license that's been introduced, could you describe, first of all, the importance of this type of license, and also whether it's going to be necessary for there to be any type of minimum capitalization requirement to that? Like, I guess what I'm saying is, do you require, what are the eligibility for getting one of those licenses? Does it require a medical license first?
It does not require a medical license first, no specific capitalization requirements. So the general conditions for eligibility for licensure overall would apply in the same way for a designated consumption establishment. And when we looked at the types of special licenses that could be created, and I will say that as a regulator, it's not often that you get delegated some authority to be a little more creative and look at what the industry may need to be successful. So that was a nice twist in the ballot initiative that we had the opportunity to do that. I hear a lot, having been a regulator for 15 years now, about things that the industry wants to see created and participants think would be beneficial that need to be done statutorily. And unfortunately, that's not always the easiest thing to achieve. If you see an opportunity for business growth in the state, a market that needs to be served in a certain way. So when we looked at that, we saw that social consumption was a burgeoning issue in many states in recent years. Right. You look at, say, Colorado, they'd had a program in place for years and eventually got to that place of social consumption, that we figured, why not take it on head on right at the beginning and try and put something in place that allowed for that to occur. And Michigan, being the first state in the Midwest to have a law that legalized adult use, and Michigan already being a tremendous state for tourism, that if individuals were coming to the state and legally able to purchase marijuana products, they needed some place that they could use those products. So
right,
we weren't
can't trapping
go to the
hotel,
them.
Right?
Right. So you don't want to trap people into committing crimes when they're coming here to be a tourist. So I think these social consumption facilities will serve a good purpose there. Having the ability for a licensed establishment, particularly a retailer or a micro business, to have a separate area where they can allow for consumption is a good approach to that. And then having secondary licensure available to any facility as long as it meets the conditions, and not have sales, but allow individuals to bring their own products and consume them on site, will provide a good opportunity for individuals to ensure they're engaging in activities where they're consuming marijuana in a safe way, and that we have some degree of regulatory oversight, again, without being too onerous.
I think it just makes sense, right? I mean, we're trying to regulate marijuana like alcohol. Alcohol, there's a purpose and a reason why we have places like bars, right? People where they can consume alcohol. Just makes sense for cannabis, I think, as well. And it's great not only for the industry, but for society, because, as you said, we have people coming here to the state and they need a place to use, but also we've seen in other states, and it's great that we're able to learn lessons from other states, but we've seen in other states arrests go up, not because of marijuana being illegal, but because consumption that people are using in public. And the fact that we can have these type of establishments where people don't have to do that is clearly the right thing to do. And I'm very excited for having the opportunity to be able to have that in Michigan, and very shortly, I would think. I noted that the rules addressed and seemed to contemplate the fact that there may be some shortages in the supply of cannabis within the industry in order to meet demand. And it seems as though that the rules seek to provide you the opportunity, the agency, the opportunity to address that. Can you talk about how particular the rules plan to meet that potential problem?
Sure. Well, what we've seen in the past couple of years as the commercial medical market has started to evolve in the state is that there was a large demand in the state already, and getting the regulated supply up to the place where it can meet that demand has been one of the main challenges. And just on an initial reading of the ballot initiative, you're restricting, the law restricts the number of participants there, and further restricts the ability of those participants in terms of the size of their operation, but to serve a larger market. So that was obviously an area that we thought needed to be addressed in the rules. And the creation of that excess grower license, I think, provides two purposes in my mind. It gives operators an opportunity to grow beyond the capacity that's specifically allowed by the license types dictated in the statute, but also ties it back to operating in the medical market, because we want to be cognizant of the medical market still existing, the number of patients that may still need to have access through the commercial medical market, so that we don't want all the operators in this space to move their operations from the medical market strictly over to the adult use market. So I think it serves that purpose in creating some balance there as well.
In talking about this combination, a potential combination for medical and recreational, I know the rules have contemplated this as well. If you go to Colorado right now, you'll see those that have multiple licenses, they have to literally have separate rooms in order to be able to have a retail for medical and for recreational. It seems as though that these rules are not going to necessitate that. Is that correct?
That's correct. And this is where having those work groups that we've had over the past several months and really engaging with stakeholders, that was one of the main things that we heard about. That the operators in the space didn't want to be burdened with having to completely separate operations. And it made sense to us. There's no inherent difference in the statutes between the plants or the products being produced. So there really wasn't a specific need to completely separate facilities. In addition, the ballot initiative specifically calls out the fact that we can't prohibit the co-location of medical facilities and commercial establishments. So we wanted to make that as simple as possible, but still recognizing the fact that we're going to be tracking these products through the statewide monitoring system slightly differently, so wanting some tracking separation there, but not require them to completely physically separate facility types.
I think that's going to be very welcome to the industry. Just by myself seeing how it's been segregated in other states, just seemingly didn't make a lot of sense. And so again, we're learning on other states and other people through their work groups. Nick?
Yeah, and I think too, just kind of to go off of the concept of being industry friendly, I know there were a few things that are a little bit different compared to the medical laws and to the adult use laws, which is kind of allowing the industry to give trade samples, internal product testing samples, and engage in kind of research and development. Kind of gives a way that, you know, depending on what kind of sample it is, it definitely has to be tracked, but either tracked and or tested, sent to either employees to give their feedback on the quality and whether to sell it as a product, giving it to other licensed facilities to also allow them to purchase it, and then just to also engage in that little bit more experimentation for developing different products and uses. I think that's just another feature being industry friendly. Is that kind of something that you gained from the work group, since a lot, since the beginning is kind of a pro industry trend?
Absolutely, and having the opportunity to regulate the medical side of things and getting some operators involved in that space, those were the areas that they called out as being beneficial to them, so they could do some of the things that you talked about there. And we want to treat operators in the marijuana space as much like businesses in any other industry as possible. Understanding there's a high regulatory requirement here, and that we need to have pretty strict oversight of the facilities. But if they're going to operate in a compliant manner, opening some of those doors and not blocking all of that off and keeping it so strictly regulated so that they can't develop new products and they can't engage in normal business practices. If you look at the trade samples, if you're trying to establish business relationships, if you're a grower or a processor with a new retailer, they're going to want to see the products that you're offering and ensure that they think they're quality products and that they think they can sell those products. And that was perfectly reasonable to us. It's not something that necessarily was contemplated when we were implementing the medical program. Everyone was kind of learning together. So we want to be cooperative with industry, hear their ideas, and if we can figure out a way we think things can be done without sacrificing consumer safety, then we're happy to open those doors.
Definitely, and also to kind of go off of that, I also noticed another feature of the law was reasonable access to marijuana, where, acknowledging the fact that right now the industry is still up and running, there are going to be the medical licensees that convert over to adult use, but one of the features was to not have that kind of hamstring the rest of the industry. And there's direct language in the rules saying that if these licensed facilities are going to play and enter into the system, they can't just kind of be selfish and not share the product, so to speak. So that kind of allows a mechanism for the agency to make sure there's enough supply, not only to the ones with common ownership, but to those smaller businesses and ones that don't have a kind of stronghold on the industry right now. So I also thought that was another, kind of goes both ways, where you're allowing the licensed facilities to give trade samples and testing samples to their employees, but also saying, play fair with everybody else and make sure that the supply actually goes to every bit and piece, and rural areas too that are underserved right now with medical facilities.
Right. We don't want to restrict businesses from being vertically integrated. We have quite a few of those in the state, and if that's the business model they choose, they're welcome to do that. But to your point, we also want to ensure that there's adequate access in all parts of the state. Municipalities obviously play a role in that in terms of adopting authorizing ordinances, but that has been a bit of a challenge to get the products in the right places to the right people, and we want to play a role in that. And that's not something where we want to be too heavy-handed in dictating how businesses can operate within a free market. But if we see that there might be an issue in terms of access, and again, we're trying to create an environment that can replace what exists in the black market. So providing businesses the opportunity to fulfill those needs in every way possible, but doing so again in a way that protects public safety, then we need to play our part in creating that environment.
Let's shift gears to social equity. We know that the Regulation and Taxation of Marijuana Act calls for a program in order to assist or identify and assist areas and individuals that have been disproportionately impacted by cannabis prohibition. We see that the rules have addressed that, I think, summarily a little bit, and I would imagine that the agency, in fact, it references the fact that the agency is planning on introducing a more comprehensive plan. Could you talk about when that may happen and what it may look like?
Sure. We intend to issue that plan sometime in the month of July, and I think doing it in such a way that we provide that sort of summary framework, as you referenced in the rules, but publishing the plan separately gives us some flexibility. So it's not carved in stone, and year to year we may have that vary as well, depending on what we see being effective, what we see as being additional needs to help partner with the communities that we identify. So when that plan is published, you're going to see which communities have met the criteria for being qualifying communities, and individuals who come from those communities, what they need to do to be individually eligible, and what types of services we can offer. And we're one piece of that broader puzzle, I think, when it comes to helping effectuate that social equity component of the ballot initiative. But we want to make sure that there's clarity there, but we provide ourselves flexibility to appropriately address it. Anytime, rules are more flexible than statute in terms of how they can be amended at times, but we want anytime we have a new issue that we're dealing with, and the social equity doesn't exist on the medical side, giving ourselves the flexibility so we can learn as the program's implemented and we can see whether it's successful or not, I think is going to be critical. I think other states, as they've implemented similar social equity plans, have particularly focused on how to give licenses to those individuals from the communities, but we're going to measure our success against sustained licensure, access to employment within the industry, and giving ourselves flexibility in the plan allows us to address those things if we don't find that we're achieving the results that we expected.
I didn't consider the fact that by perhaps having a plan that's separate from the rules, it gives the agency a lot more flexibility with respect to changing it, amending it, perhaps. It's not, I don't know if is it going to be part of the rules or it's just going to be separate from the rules, which perhaps, because we know that the rules are emergency rules. You have 6 months to create permanent rules.
Right.
These were done in order to address an emergency scenario, but having a separate plan, I suppose, acts outside of that. Is that right?
It does, and it references back to the rules themselves. And if we determine ultimately that the plan that's in place is effective and meets the conditions that we hoped it would and is affecting the communities in the way that we hope that it would, then we can certainly just put all that in the rules and leave it there. But for the short term, being that this is a new concept to the state and that we'll just be beginning to work not only with the communities themselves but those individuals and also partnering with any other outside organizations or groups, that we may learn things along the way, and we want to be open to putting more into that plan as we go.
I noted that the marijuana establishment plans, which is kind of like the equivalent of the marijuana facility plans on the medical side, it also necessitated that licensees, or the applicants actually, will have to submit a social equity plan to be included within their application that addresses, I think it calls for that perhaps the identification of those that are historically disproportionately advantaged, and what are they going to do in order to address those particular concerns or issues that are mandated by the Act. So I think that's great. How do you think that that's going to work out as far as the agency's ability to be able to follow up and ensure that these licensees are going to actually implement the plan? I think that a big fear is going to be, well, yeah, they have a plan, but are you really following it? Do you really mean to really do something about that, or you're just doing that because it's something that's contained within the rules?
Sure. And from one aspect, the social equity plan to be submitted by applicants isn't a regulatory requirement per se. So they're not going to be disciplined for failure to comply with that plan. So that is, our reach in terms of that is not as strong as other provisions of the Act or the rules when it comes to compliance. However, in speaking with a lot of licensees in this space, they have a lot of the same objectives that we have when it comes to the success of the social equity provisions of the statute, and I think they want to be partners in that. We have access to resources to provide to the social equity communities and participants, but I think the industry itself has a lot that they can offer as well. And as I referenced before, we're not just talking about providing specific licensure to individuals, but there are other opportunities in the industry as well when you look at job creation and job growth. And for example, one of the things that we certainly can't offer individually is any sort of expertise in how to grow marijuana or process marijuana. That's not necessarily what our agency can provide. So we want to lean on the industry to provide that as well. And in terms of accountability, we are going to take all of those plans that are submitted by applicants and publish those on our website and publish their updates when they renew them as well, so they can be accountable to themselves as well as the community as a whole when it comes to how well they're effectuating their part of that plan and being a partner with us in ensuring that we're meeting the statutory guidelines.
Did you have a question?
Oh no, I definitely, just to kind of add on to that, I think that's a good idea. It's, might not have as much teeth as some of the ballot initiative actual criteria, but to request one and require it gets each of the applicants and licensees thinking about it. Not that they aren't, but they definitely kind of putting the plan into words. That's really good that it'll be published so that it can kind of, shared ideas and them holding themselves accountable, because they certainly wouldn't want to publish something and shoot for the moon when they're really not going to plan on actually doing something. So I think, kind of a two-pronged attack where, the MRA is going to be sharing that list of resources and creating the list of communities to encourage participation, but also on the applicant side, really, opening up the doors to having those, kind of shared conversations and working towards a shared goal, like you mentioned.
Speaking of compliance, perhaps we could conclude on what I see to be something that people aren't talking about a lot is the agency's obligation to begin to inspect these, or not just inspect them, but begin to actually take action on compliance and like perhaps some penalties being imposed. And I know that the agency is not necessarily trying to do that and wants to more work with partners with a lot of these licensees, but I can envision a time when there's going to be a bit more enforcement on these rules, and of course the penalties that are contained within. Can you comment on that? Sure. Because I think licensees really need to know that there's going to be some stepped up enforcement, and they have to be held accountable not only to the plans that they submit with their applications, but also with the manner of which that they operate.
Sure. I do think it's important when it comes to our role as a regulatory agency that there are times that you have to shift from coaching into punishing. There are certain violations or patterns of violations that start to look toward, risking public health, safety, and welfare, and we need to start taking action. And we focus a lot of our energy, because this is a new industry, it's highly regulated, and we're dealing with a lot of business operators that, if operating in that gray market previously, 2008 to 2016, needed some help in understanding how to adhere to the requirements. You look at, say, using the statewide monitoring system, that was new to all of us. So we didn't want to be too nitpicky when it came to mistakes that were made there, just help people run a compliant operation. But you're absolutely right. We're getting to that point now where we're going to have to turn our attention not only into continuing to educate and coach so that individuals can run a compliant operation, but if there are violations of the act or rules where there may be situations where we have to take action and issue fines, penalties, suspend licenses for periods of time, and potentially even take licenses away for individuals that demonstrate a lack of ability to run a compliant operation, either willfully or just out of a lack of capability, because there's a lot on the line here. Businesses are putting tremendous investment into this marketplace, and there's a lot on the line when it comes to patient and consumer safety as well. And that's an important part of regulation, is that not everyone can be allowed to continue if they can't abide by the rules.
Thank you for that. So, Nick, do you have anything else?
Yeah, I think just kind of also to close out, we had mentioned that a lot of municipalities are opting out just in anticipation of the rules. Now that they're out, do you kind of, obviously not urging them to or not to opt in, but do you have any kind of, words of wisdom as far as how they're to proceed now that the rules are out with the next 4 months? I know they have some time to digest that, but if any, going there now, having the rules in front of them, I know even with medical, sometimes there would still be, some criticisms that they weren't too fleshed out yet for them to feel comfortable to do that. But I think that, the adult use rule set is 64 pages, I think, and it's more significant than, a year and a half ago when the emergency rules for medical and then permanent rules came out. So do you have any kind of words of wisdom for municipalities?
Well, I think the thing I want to encourage more than anything is to start looking at things and determine what the best approach is for each municipality. Unlike on the medical side, there's not an opportunity to sit on the sidelines and wait. If we receive those applications, and we will starting November 1st, and there isn't a municipal ordinance in place at all that addresses this, then we're compelled to issue a license. So I think it's critical that every municipality takes a look at the rules and takes an approach to this. If they determine that the facilities aren't appropriate for their jurisdiction, they simply need to put an ordinance out there that says that. They always have an opportunity to opt in later. They can change their ordinances at any time. We just want to make sure that they've had a good opportunity to consider the state's approach to things, fill in the gaps where they feel it's necessary, and take the approach that's best for the citizens of their community. And when it comes to applicants for licensure, particularly those who aren't known to us on the medical side, I think it's important for them to look at the rules as well and understand what the conditions are for approval. You gentlemen represent a lot of applicants, so you know that getting an application perfected to the point that we can approve it is not necessarily as easy as it looks on paper. There's a lot of documentation required, and when it comes to passing an inspection, there's a regulatory inspection from our agency, there's a fire code inspection, you have to pass building code inspections as well. And that 90-day timeline, I think, was put into the statute to bind the agency to make sure we weren't dragging our feet. But in the end, I'm more concerned that it'll be a negative implication on applicants who have challenges if they're starting a brand new business to get everything we need so we can get them through the background check phase and get their facility into condition so that we can approve it. So we built in that two-step process that we have on the medical side as well. So I want to encourage new applicants who aren't already licensed on the medical side to submit that step one, get through that process, get your pre-qualification approval, and that way you have 90 full days to submit that Step 2 application, pass all the inspections, and get your license. I don't want people to be denied at 90 days simply because they couldn't get the paperwork together in time. They couldn't correct some deficiencies through the inspection process and then have to reapply.
Mm-hmm. Yeah, and that's another, just to kind of add on to that, there was another feature I saw that was baked in there, pun intended, I guess, that it was a 5-day deadline to respond to deficiencies, and then there was a 60-day deadline to kind of have a physical facility and have it inspected and pass that. So it seems like you're creating these, not to say barriers, but realistically, I'm sure there are a lot of people that got Step 1 approval just because so many municipalities decided to opt out. There weren't a lot of physical locations. So it's kind of almost seems like the MRA is saying, come to us when you're ready, make sure you have things and all your ducks in a row, and then apply, and then you have these deadlines to kind of meet. So make sure you have everything together,
Right.
before you submit, so to speak.
Absolutely. I think, preparation is key. And reviewing, we'll put out the application well before we start accepting them. We'll put out checklists. We'll do presentations on how to work through the application process. But in the end, it seems very simple, I think, from the outside looking in to say, why would it take more than 90 days to process an application? But we have hundreds and hundreds of these on file at the same time. So, to get yourself in the queue and get it worked through, and everyone wants their application to be processed quickly. So if there's a deficiency notice that has to be sent, now you're working to the back of the line again. And when we're working against that 90-day time frame, we will issue denials if the application can't be approved at that 90-day mark.
Good to know.
So just announced that the agency will begin taking applications on November 1st,
Yep.
potentially issuing licenses by February, 2020, right?
I think we might issue licenses in November even to some of those.
All right, because they've already been...
They've been through the process.
Right.
We just have to conduct the inspection.
Right, so latest February. So
Mhm.
that's super exciting. Will there be, I presume we'll also see an application that's similar to the medical marijuana applications. Will it be released anytime before November?
Yes, we intend to get that out earlier in the fall so everyone has a chance to review it and digest it, start filling their paperwork out, start gathering the additional documentation that's necessary. The form intends to try and push everyone in the right direction to get all the information we need, but in the end, when we're doing background evaluations, every person's situation is different. So the documentation they have to gather is very individualized in many cases.
Sure.
And also so they understand what we're going to be inspecting on the facility itself. So those that are already operating in the medical market can make any changes that are necessary to ensure it complies. And then individuals that are operating new facilities or trying to start those up have a sense of what we're going to be looking for when we come in to do that inspection.
Okay. Well, Director Brisbo, thank you very much for coming on the show again and talking about this very, very important set of rules that we have. Again, it's going to be very exciting to see them implemented. And so we're going to wrap it up for now. We're the Cannabis Legal Group. This is Cannabusiness Live. This is going to be, it has been every Friday. This is our 101st episode, which we're very proud of. We're going to continue to do this because we know that it's important to the industry and to people that are interested in knowing what's going on. Thank you guys very much for watching.